The recent decision by the Department of Justice, DOJ, to appeal to the Supreme Court, seeking to overturn injunctions blocking an executive order on birthright citizenship, initiates a major constitutional confrontation. This executive order attempts to restrict the granting of automatic U.S. citizenship to children born in the United States unless at least one parent is a U.S. citizen or lawful permanent resident. This move directly challenges over 125 years of established legal precedent under the 14th Amendment. Summary of the issue and legal grounds. The core of the conflict lies in the interpretation of the Citizenship Clause of the 14th Amendment, ratified in 1868, which states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." For over a century, guided by the landmark 1898 Supreme Court case United States v. Wong Kim Ark, this clause has been interpreted to grant citizenship just solely by right of the soil to almost all children born on U.S. territory, with exceptions only for children of foreign diplomats and occupying forces. The administration's argument, articulated in the appeal, contends that the children of undocumented immigrants and temporary visitors, such as students or tourists, are not fully subject to the jurisdiction of the U.S. because they owe ultimate political allegiance to a foreign power. Therefore, the executive order seeks to implement a more restrictive interpretation, requiring a parental connection, citizenship, or lawful residency for the child to qualify. Reasons for the appeal and policy analysis. The administration's push to end universal birthright citizenship is driven by both policy and political objectives. 1. Border security and migration incentive. The primary stated policy reason is that universal birthright citizenship acts as a powerful incentive for illegal migration and encourages birth tourism, where individuals allegedly travel specifically to the U.S. to secure citizenship for their children. The administration argues that limiting automatic citizenship is essential to strengthening border security and reducing unauthorized immigration. 2. Legal reinterpretation. Legally, the administration is challenging the broad consensus established by Wong Kim Ark. Solicitor General D. Sauer argued that the original intent of the 14th Amendment was to grant citizenship to formerly enslaved people and their children, not to confer the privilege on the children of illegal aliens or temporary visitors. By focusing on the concept of complete political allegiance, the appeal attempts to persuade the conservative-leaning Supreme Court to adopt a narrower, revisionist reading of the clause. Consequences of a potential change. If the Supreme Court were to overturn the established precedent, the consequences would be immense, immediate, and destabilizing. 1. Creation of a stateless class. The most significant humanitarian consequence would be the immediate creation of a large class of children born on U.S. soil who would be denied citizenship. Many of these children would effectively become stateless or be forced to claim the citizenship of their parents' home countries, often with complex and slow bureaucratic processes. This fundamentally undermines the 14th Amendment's goal of preventing the creation of a hereditary caste of non-citizens vulnerable to exploitation. 2. Administrative chaos and two-tiered system. State and local governments which handle birth certificates and vital records would face administrative chaos. Hospitals and registrars would be forced to determine the legality of parents' immigration status at the time of birth, creating a massive new bureaucracy. This would lead to a patchwork of citizenship, where a child's rights depend on the state or jurisdiction in which they were born, undermining the consistency of federal law. 3. Constitutional precedent. A ruling against Wong Kim Ark would be a historic overturning of a nearly 130-year-old constitutional principle. Such a move would erode public confidence in the stability of core constitutional amendments and further politicize the judiciary. Prediction and potential solutions. Prediction. Given the constitutional importance and the stark difference between the lower court rulings and the administration's position, it is highly likely the Supreme Court will grant certiorari, agree to hear the case. A final ruling is likely to occur by mid-2026. While the court has a conservative majority, challenging a long-standing precedent like Wong Kim Ark is legally fraught. The most predictable outcome for the administration would be a ruling that upholds the narrow interpretation, but does so through highly complex or fragmented opinions, further signaling that birthright citizenship is now politically and legally vulnerable. Solutions. This complex issue has three potential routes for resolution, outside of the courts. Congressional legislation. Congress could definitively clarify the phrase "subject to the jurisdiction thereof" through new legislation. This approach, however, would face massive political hurdles in a deeply divided legislature. Constitutional amendment. For those wishing to entirely abolish birthright citizenship, a constitutional amendment would be the most definitive but most difficult path, requiring ratification by 3/4 of the states. SCOTUS upholding precedent. The simplest resolution would be for the Supreme Court to uphold the current interpretation, thereby settling the matter and avoiding the political and humanitarian chaos threatened by the executive order.